1:1 split verdict by the Delhi High Court on criminalisation of marital rape. Justice Rajiv Shekhar says, crime to rape your wife. Justice C. Harishankar says, no, it's not a crime. Both judges note, issue involves a substantial question of law and therefore would have to be considered by the Supreme Court. Marital rape case now to go to the apex court. Till then, Indian men can legally rape their wives. No does not mean no in a marriage in India. Not all rape is rape in India. Top focus on To The Point. Good evening, viewers. You're watching To The Point. I'm Preeti Choudhary. While today is definitely a day to celebrate the Indian judiciary over putting a stay on the archaic sedition law, it is also a day to question how long will it take before India makes it illegal for husbands to rape their wives. A two-judge bench of the Delhi High Court today pronounced a split verdict on criminalisation of marital rape. The bench was hearing a batch of petitions demanding marital rape be criminalised, while Justice Rajiv Shekhar struck down the exception 2 that protects men who have forced non-consensual intercourse with their wives from criminal prosecution under Section 376 IPC. The other judge in question, Justice C. Harishankar, disagreed, saying that the exception doesn't violate Article 14, 19 and 21. However, both the judges agreed to grant certificate of leave to appear before the Supreme Court as the matter involves substantial questions of law. The petitions seeking criminalisation of marital rape were pending before the court since 2015 and 2017.
Justice Shekhar has also said that there is no default presumption that the husband has raped, which is something that we had also argued quite strongly and clearly, that there shouldn't be a default presumption just because a prosecutrix has said that there's a rape.
ये split verdict जो है, ये society का situation को दर्शाता है, क्योंकि ये मानना कि इस मुद्दे पे सिर्फ एक ही राय हो सकता है, is not possible. लेकिन मैं ये भी क्लैरिफाई कर देता हूँ कि कोई ये किसी का पोजीशन ये नहीं हो सकता है कि मैरिज के अंदर या मैरिज के नाम पे कुछ भी हो सकता है. पोजीशन किसी का ये है ही नहीं, ना हमारा कोर्ट के सामने ये था.
All right, viewers. Now, I want to just take our viewers through on what is the current government stand, because the government has also a stand in all of that. The Solicitor General, in fact, till now, the government, the current day's government stand has been that criminalizing marital rape will interfere with the institution of marriage. However, while hearing these petitions, there's been a change of stand where the governments come into question, the current government of the day. The government has changed its stand in court. It sought more time. It says we are taking every stakeholder on board and we need more time, which the court refused. The government till now is neither supporting nor opposing criminalizing of marital rape. But till a very short back, the official stand of the current day's government was that criminalizing marital rape interferes with the institution of marriage. I just, want, for the benefit of our viewers, take you through on what is, the list of countries that India actually stands on. While most of the world has criminalized marital rape, India stands with very few countries where till now rape in a marriage is legal by the purview of the law. Countries like Pakistan, countries like Botswana, Iran, Iraq, Bangladesh, Afghanistan are countries where India stands with, while most other countries have criminalized spousal rape in a marriage. Even England, from which we got the marital law rape in 1991, viewers, took the law down, repealed it, criminalized marital rape. But for us, marital rape still continues. Until now, very recently, if we criminalized it, the explanation was it would interfere with the institution of marriage. I'm going to cut across to the petitioners in this case. There were two petitioners who will now be approaching the Supreme Court, Karuna Nundy and Colvin Gonsalves. I have with me one of the petitioners, Karuna Nundy. She's an advocate. She is one of the key petitioners. Ms. Nundy, appreciate you joining us. I believe now you would be approaching the Supreme Court.
Yes. I appear for two petitioners, the lead petitioner, the RIT Foundation, as well as the All India Democratic Women's Association, which has a 10 million registered membership. It has registered membership of 10 million women. Yes, we will be approaching the Supreme Court. We welcome and laud Justice Chagdhar's judgment and believe that this robust judgment will serve us in good stead. The judgment just came out. And it has been said very clearly that there is an intelligible differential between, or rather, there is no intelligible differential, I beg your pardon, between married women and unmarried women and separated women who are raped. That Article 15 does not brook the kind of discrimination that is occurring against married women. That when you come with a right to say no, it also makes it possible for you to say a joyful yes to your husband in the context of marriage, neither of which exists right now. And so women are reduced to legal subjects, to sexual objects in the context of marriage, which is why men's associations are supporting us and have also intervened in the High Court to say that we want the women that we are with to be able to say a free and joyful yes to us. We stand with our wives, we want equality in marriage. And let me be clear, this is a case about people against misogyny and citizens against patriarchy. This is a case where the people are asking the courts to get our government to enable these rights. And if not for the courts to enable these rights, this is not a case against the interveners. This is not a case against these men's rights associations. Yes, they must be heard, but it's not a case against them.
You know, I'm going to quickly introduce our other guests, but I want to just stick to, because you're one of the key petitioners, and I'm going to come back, to them. Urging your patience, Brinda Adige and Mihira Sood. I'm going to come right back to you, but I want to cut across to Ms. Nundy first. Ms. Nundy, I want to, you're going to the Supreme Court, and we were just, I was sifting through a lot of paperwork today where the Supreme Court has spoken, where marital rape is concerned. One might say the executive has led women down, but so has the judiciary. Of late, the instance of a former Chief Justice of India twice condoning marital rape, actually, saying that, and we're going to put out those graphics there, what the Supreme Court in terms of the judiciary has said about marital rape, really not coming in and getting the back of women at all.
Our rights are currently before the judiciary, and it would not be appropriate for me to speak on this.
All right, I get that. I get that, and you're approaching the Supreme Court from here on. But would you take us through the entire expanse of the legal battle where India is concerned and the stand on marital rape?
Well, this case began in 2015, and we argued the whole case once before a bench of the then acting Chief Justice Geeta Mittal. At that stage, the government had filed an affidavit saying many things, but including the fact that the institution of marriage cannot be impacted. And of course, to that our response is that surely rape desacralizes marriage, and it cannot be a part of the institution of marriage. Secondly, they said that India is a country of poor and illiterate women, and hence marital rape should not be decriminalized. I think to which the answer should really be that if you are poor and illiterate, I mean, surely part of that responsibility is that of the government, one. But secondly, and far more importantly, does that mean you have to put up with rape in any context? the government has an opportunity here. The government then subsequently, the SG, the Solicitor General, did say before the court that they were not taking a stand, that they were not for the, they wanted to keep the exception on the book. He said that they were not taking a stand either way. So it appears that the government has taken some steps back. But one would urge the government to see the rights that are at stake. That married women are being sexually assaulted as we speak. That, you know, that thousands of women are being sexually assaulted as we speak and raped. And the exception to Section 375 says that married rapists have a conjugal right to penile vaginal rape and also anal rape and gang rape. There are cases that have emerged that we placed before the court. And this is an opportunity for the government to either pass legislation and get rid of this block on the Constitution and on our democracy, on our constitutional democracy, or to appeal the dissenting judgment and to take it to the Supreme Court.
Well, you know, Ms. Nundy, appreciate you taking out the time. I know you're rather busy. Thank you there. We're going to let you go, and more power to you and your co-petitioners there, who are now going to be approaching the Supreme Court. I want to now cut across to our two other guests and appreciate the patience. Mihira Sood, lawyer, Supreme Court, and Brinda Adige, social activist. Ms. Adige, I want to ask you that question, which clearly at this point of time, because Karuna Nundy is directly involved, she is approaching the Supreme Court, is how Indian women have constantly been let down by both the judiciary and the executive. Even if we look at the Supreme Court, the kind of statements that have come with the highest echelons of the apex court have been downright demeaning, where marital rape comes into question. The sheer fact, Article 14 of the Indian Constitution, which deals, criminal law being discriminatory against women who are raped by their own husbands itself.
You're absolutely right. The judiciary, the elected representatives, the parliament, that should actually stand by women, especially because they profess equality, because it is a constitutional guarantee. The government also talks about women's rights, empowerment, enabling women to live a life without violence in any sphere. This particular issue does not show that they believe or they even want women to have all of this that they say. Now we must understand that very, very strongly they uphold the concept and thought that women are properties of their fathers, their husbands, their sons, and in a marriage, of course, property of that husband again. The personhood of the woman is not being recognized nor respected. Her dignity is not given an iota of importance, where they talk that if the woman in a marriage is being raped by her husband and she's about 15 years of age, then she must not report or complain about it, because it is her sole responsibility to look after the, uphold the sanctity of family. So what is my government actually saying, or my judiciary saying or implying, is even at the cost of you being raped, where your consent is not going to be given any credence, you uphold the institution of the family. That is why we will not criminalize marital rape. And like you pointed out, 150 countries have criminalized rape. 36 countries, of which India is also one of it, refuses to criminalize. Now, in the other, during the day, we had some people talk and say, but you already have a Domestic Violence Act. The Domestic Violence Act is a remedial act. It does not penalize. It talks about sexual violence, but it doesn't talk so much about rape. Rape is a heinous crime and talks about consent. And in that, you need a lot of other kinds of evidence to prove it. That is why a separate law.
I want to bring in Mihira Sood as well. Mihira Sood, you're a Supreme Court lawyer. Has criminal laws in this country at some point of time completely disregarded women who are married and discriminatory against women who are married?
They have. We've had an entire range of laws that have done that. And I think what's important to note is that in the last few years, we've also had a raft of decisions by the Supreme Court that have sought to overturn that, whether it was the privacy decision, the 9-judge bench privacy decision in Puttaswamy, and explicitly linking it to sexual autonomy. We had, Navtej Johar on 377. We had the right to choose one's life partner in Shafeen Jahan's case. And most importantly, I think, in the case of Joseph Shine, that case really applied the lens of constitutional morality to the matrimonial relationship. That was a case that struck down the law criminalizing adultery. And I think that's going to be an extremely important case for the Supreme Court to look at going forward, because it specifically talked about how these outdated notions of marriage and outdated stereotypes of a woman's role in the matrimonial relationship do not pass constitutional muster. That outdated notion of marriage is at the heart of the marital rape exception. That outdated notion of marriage is also at the heart of a similar case pending before the Supreme Court, which challenges the constitutionality of the provision of restitution of conjugal rights, which prevails across different personal laws, Hindu law, Muslim law, Christian law. And I think that is going to be, the big challenge before the Supreme Court, because these two cases will have to be decided keeping in mind, the issues raised in the other. And I think that's what's going to make it complicated. And I think both these cases, to my mind, are bound by the decision of the 5-judge bench in Joseph Shine's case.
I want to quickly, take one question each from the both of you. Brinda Adige, is it time right now? Because if the government ever has intent, and if you look, you go back in history, they've constantly, successive governments, the executive have completely led women down on the case of marital rape, be it the submittings of the Law Commission. I would reckon the only time that it came to light was in 2018 when Shashi Tharoor introduced a private member's bill asking for the criminalization of marital rape, but the bill lapsed because there was no consensus which was reached. Is it time? Because if the government has intent, there are various laws it pushes through, ordinances, and we've seen a lot happen of late, that they could do so with this as well, but there is no intent.
Definitely, definitely. Oh, sorry, was the question for me?
Either of you can take it. Ms. Sood, go ahead. You go ahead. Brinda Adige, I'll come to you after that.
Sorry, I thought, anyway, just very quickly, yes, I do think that if the government had intent, it could have done so. It's done so with many other laws for which it does have intent. But I also want to push back a little against the idea that this is something that is purely in the Parliament's domain, and separation of powers requires the court not adjudicate on it. The court cannot make laws, that is correct. But the court is well within its power. In fact, it is the court's duty to decide the constitutionality of laws that are challenged before it, and to not do that is an abdication of its duty. So it is not respect for separation of powers that should decide whether or not the court
okay, Brinda Adige, very quickly.
Issue. It is very much the duty of the court to look at the constitutionality and rule on that. This is not lawmaking. This is an assessment of law that already exists.
Brinda Adige, your point of view.
Yeah, absolutely. It is the intention of our elected representatives, policy and lawmakers, which is lacking just now, and that needs to really buck up, strengthen, because 50% and more are women, and they cannot sit on stereotypical concepts and patriarchal mindsets, misogyny and sexism to say that a woman can be raped simply because of the agreement or contract of marriage that she has got herself into.
All right, I appreciate you ladies for joining us. I would reckon for what's going down in court also represents our society in a country that we live in, where many still believe, like a lot else, once married, a woman hands over perpetual consent to her husband, practically till death do them apart.